We're going to kick it off with our continuation on our fishery management plans. We're going to Amendment 2 to the Estuary and Striped Bass FMP update. Nathaniel and Charlton, would y'all come up and give us your presentation, please?
Laura, can you log in? I can do a lot of things with the computer, but that's one thing I can't do.
Yeah.
Is that one front and center right there?
Yep.
Thank you. Yes, please. It's just slow, maybe. There it goes. All right. All right. Thank you, everybody. I'm Nathaniel Hancock, one of the co-leads for Estuary and Striped Bass for the division. Next to me today is Charlton Godwin, the mentor for the Estuary and Striped Bass Fisheries Management Plan. Today we're going to be focusing only on the Albemarle Roanoke River, or AR stock. We will discuss the stock assessment, adaptive management measures under Amendment 2, and the Albemarle Sound Stocking Contingency Plan. I should note that this presentation is for informational purposes only, and no action is needed at this time. To start with a quick overview of where we stand currently, the division completed a peer-reviewed stock assessment for the AR stock in August 2020, using data from 1991 to 2017. In November 2022, the Commission approved Amendment 2 to the North Carolina Estuary and Striped Bass Fisheries Management Plan. And between November 2022 and February 2023, the division completed a peer-reviewed stock assessment update, adding data up to 2021. The Commission received a presentation in May reviewing the findings of this stock assessment update. Today, we will be reviewing that stock assessment update that was presented in May more briefly, considering AR striped bass monitoring indices, and discussing steps moving forward for the AR stock. Beginning with a quick review of the AR striped bass stock assessment. For this stock assessment, the stock unit includes all striped bass within the Albemarle Sound and Roanoke River management areas, also known as the AR stock. The division manages commercial and recreational harvest in the Albemarle Sound management area, also known as the ASMA, and the North Carolina Wildlife Resources Commission manages recreational harvest in the Roanoke River management area, also known as the RRMA. The Central Southern Management Area, or CSMA, is shown here for reference. It's comprised of 3 additional striped bass stocks that are not included in the stock assessment that we are reviewing today. The primary results we evaluate from the stock assessment model are spawning stock biomass and fishing mortality. This plot shows spawning stock biomass, a measure of the reproductive female population of striped bass. In brief, the takeaway is that, based on the stock assessment, spawning stock biomass is lower than the threshold, meaning that the stock is currently overfished. Moving on to fishing mortality was greater than the threshold for sustainable harvest, so overfishing is currently occurring. Because of gaps in survey data due to COVID interruptions to sampling and variable results from survey standardizations, we decided to reach back out to our peer reviewers to evaluate the stock assessment update results. The review panel felt that how the data were handled during COVID-19 was an appropriate approach. Also, that the base model's estimates of decreasing recruitment and abundance agree with general data trends, the trends estimated in the benchmark assessment, and trends across sensitivity runs. The review panel felt that overall, the model results are a credible representation of current stock status. Namely, that since the benchmark stock assessment, spawning stock biomass has remained below the threshold, that annual recruitment to the population has not been sufficient, to result in any sustained increase in spawning stock biomass, and that overfishing has occurred and is a contributing factor to the continued depression of spawning stock biomass. As was the case in the 2020 benchmark stock assessment, drivers of recruitment remain a major uncertainty, and alternative ideas around environmental drivers of recruitment warrant further exploration. The observed decline in recruitment is not believed to be entirely due to fishing, and could be a number of other factors such as flow rate and/or blue catfish predation and competition. The potential causes for recruitment decline are discussed in more detail in your memo. The peer review panel endorsed the stock assessment results for management use and concluded that the stock assessment update is based on the best science available. Despite the peer reviewer's conclusion that the stock assessment is good for management and based on the best science, there have been some concerns voiced about the uncertainty associated with the stock assessment results, particularly the low estimates of total biomass in the most recent years of the assessment. So let's shift focus for a minute from the stock assessment results to look directly at the data the state uses to monitor the AR striped bass stock. We will look at 4 major indices that we use to monitor the AR striped bass stock. First, let's look at the juvenile trawl survey that is used for our annual juvenile abundance index. Here on the X or horizontal axis, you have year, and on the Y or vertical axis, you have the juvenile relative abundance index in number of juveniles per trawl tow. I should note that the juvenile index goes back to 1955, while most of our other indices only go back to 1991. Consecutive years of very poor recruitment began in the 1970s. This poor recruitment went on for over a decade. Then, after increases to minimum size limits from 12 inches up to 18, harvest restrictions, some improvements to water quality, and specific targets for the flow regime on the Roanoke River during spawning season, the stock started producing extremely good year classes in 1993. This continued until about 2001, when the stock started producing more year classes that were below average and fewer big year classes. The last 2 above average year classes produced were the 2014 and 2015 year classes. Starting in 2017, the number of fish that the stock produced each year has been very small again. For several years, between 2017 and 2020, high flows in the spring on the spawning grounds led to the Roanoke River overflowing the banks. When this happens, eggs can be washed into the floodplains and swamps, and we don't expect a good year class to be produced. But in 2021 and 2022, flows were right in the sweet spot during the spawn, but we still saw very few juveniles produced. We're over halfway through our juvenile sampling for 2023, and based on preliminary results, it looks like another very poor year class was produced, despite having nearly ideal flows. This is extremely concerning. Moving on to the Roanoke River electrofishing survey, with data collected by the Wildlife Resources Commission, this graph shows the number of age 9+ fish per hour captured in the electrofishing survey on the vertical axis. There is a big increase in abundance of age 9+ fish when the large 1993 year class reaches 9 years old. Then, as we begin having consecutive years of low recruitment, the abundance of age 9+ fish begin decreasing. In recent years, we are seeing the same low number of 9+ fish on the spawning grounds as we did in the early 90s when the survey began. Finally, we'll take a look at the abundance of age 4 to 6 year old fish in our gillnet surveys. The spring and fall adult gillnet surveys have been ongoing since 1991. These surveys show the same general trend of decreasing abundance. The recent spike in abundance is explained by the large 2014 to 2016 year classes, but it should be noted that since 2017, recruitment has been close to 0 every year, so we are probably seeing the results of the last good recruitment years in our survey now. The takeaway here is that based on our fisheries indices alone, independent of the stock assessment, the stock is in trouble. Considering that our annual indices agree with the stock assessment just adds to the argument that the stock is not in good shape. With the adoption of Amendment 2, we've begun taking steps towards recovery and better understanding of the AR stock. To summarize recent management changes, in 2021, we reduced the TAL from 275,000 pounds to 51,216 pounds based on the benchmark stock assessment. We reduced the recreational limit to 1 fish per person per day and the commercial limit to 10 fish per license holder. We introduced an 18 to 25-inch slot with no harvest over for the Albemarle Sound management area and removed the ability to harvest fish over the slot limit in the Roanoke River management area. Moving forward, we've begun to take additional actions to recover the stock. Following the 5 consecutive years of spawning failures, the North Carolina Interjurisdictional Fisheries Cooperative, including the Division of Marine Fisheries, the Wildlife Resources Commission, and the U.S. Fish and Wildlife Service, began supplemental stocking efforts this year. Juveniles were produced from Albemarle Roanoke striped bass collected at Weldon. Genetic tagging will allow for identification of stocked versus wild spawned fish. The current plan is to stock fish for 2 more years. This will add some fish to the population and hopefully help increase spawning stock abundance when the stocked fish reach maturity in 4 years. This year, 1.4 million fry were stocked in late April and early May, and 668,000 phase 1 or 2 to 3 inch fish were stocked in June. So what's the next step? Amendment 2 to the Estuarine Striped Bass Fisheries Management Plan was adopted last November and lays out some options. The adaptive management framework within Amendment 2 that the Commission adopted instructs the division to use the results of each stock assessment to recalculate the TAL. In the case where fishing mortality exceeds the target, we reduce the TAL, or total allowable landings, to achieve the fishing mortality target. Essentially, the quota is set to a harvest level that achieves sustainability. If the estimated total allowable landings are too low to effectively manage, or the stock continues experiencing spawning failures, a harvest moratorium may be necessary. Based on this most recent stock assessment update, a TAL of only 8,349 pounds is necessary to reduce fishing mortality to the target. This is down from the TAL of 51,216 pounds in the previous 3 years, and this represents more than an 80% reduction. After the TAL is split between the 3 sectors of the fishery, this results on a TAL of 4,175 pounds for the Albemarle Sound commercial fishery and 2,087 pounds in each of the Albemarle Sound and Roanoke River recreational fisheries. Maximum daily landings over the past 3 years in the Albemarle Sound recreational fisheries were between 700 and 1,700 pounds, meaning that the TAL could easily be exceeded in 2 days. For Albemarle Sound commercial fisheries, the season would be about 2 to 3 days based on previous landing rates. We have a few specific things to keep in mind. Amendment 2 allows for a harvest moratorium if the recalculated TAL is too low to effectively manage or we see repeated spawning failures. Both of these conditions have been met. We have already been operating under a severely reduced TAL of 51,216 pounds for the past 3 years without signs of increased recruitment. The new TAL is only 20% of the previous and would lead to harvest seasons of only a couple days in several fisheries. This would be too low to effectively manage. Additionally, we have seen repeated spawning failures since 2017. With this in mind, based on adaptive management contained in Amendment 2, we will be implementing a harvest moratorium beginning in fall 2023 season and keeping the MFC updated on ongoing PDT discussions. With that, Director Rawls will be giving an update on WRC management following any questions you may have about this presentation.
Thank you. Questions, comments? Commissioner Rader.
Do we have any idea, or specifically have you tried to estimate what discard mortality might add up to from all sectors against that 8,000 some odd calculated TAL? Under a harvest moratorium. I'm trying to get an idea for what the
Well, we have
ongoing mortality would likely be.
we do have discard estimates that we use in the stock assessment for each year. Some of those are obviously based on for instance, the commercial fishery is being prosecuted. if we don't have a large mesh, gillnet fishery fishing for striped bass, then those discard estimates will be lower. And we certainly do still have, we'll continue the creel surveys, so we will have estimates of recreational releases, so we will have discard estimates as well.
Yeah, we will, but I just wondered if we do. And if we right now could guess. I understand it's a guess because conditions are changing, but sort of what
I would have to look in
what
the,
the irreducible mortality might be under a moratorium.
I would have to look
See
in the
what I'm
stock.
trying to
Yeah, yes, sir.
Okay.
I'd have to look in the stock assessment to give you the exact estimates of discards from the previous years, but it should be somewhere in that same level, even less for the commercial discards potentially.
I believe if you have a chance to look at the fisheries management plan updates, that there's a table there with annual dead discard estimates. And that should help maybe give an idea about what those annual estimates are like. I don't have that right in front of me, but I can send that to you later if you would like as well. And that's the same FMP update that Lee showed yesterday.
Yes, Commissioner Rader.
And then I don't want to take the discussion too far afield, but I am interested in the correspondence between the environmental factors that were in their stock assessment and the update identified there, and the parallel factors identified in the coastwide striped bass patterns through the ASMFC, as was reported earlier. Just wondered if you have any thoughts about now or later about what those factors might be, given that the flows are close to recruitment failure doesn't seem to be tracking that. And so the question is what those other factors might be here and abroad to have similar patterns.
Yeah, I don't think the Chesapeake Bay is experiencing most all those stocks in the Chesapeake Bay, Virginia and Maryland portions are kind of experiencing this same general decline in recruitment. They've not been as bad as ours have the past years. Those systems are a little different. So I don't think, and at the ASMFC level, I don't think that we've really identified the environmental or other causes that's driving that, and we really haven't. We know some of the issues for the Albemarle Roanoke stock, but we haven't, we really haven't identified any sort of smoking gun, you may say. We did do some ichthyoplankton, some zooplankton and larval fish sampling this spring in the lower Roanoke to kind of compare the abundance of zooplankton and the abundance of, larval striped bass to some of the work that Roger Rulison and all those folks did in the 80s and 90s. And then some of the there's been some more recent work too. We haven't gotten the results back from that yet, but that may give us a little bit better an idea of, at least in this past year, is there enough zooplankton abundance at the right time and place so those fry have something to eat, so.
Yeah, and as you know, switchover in zooplankton community has also been blamed in the past for certain failures to recover. And I guess what I'm thinking about is the river herrings, both shifts and failure to recover, and prey switching, and then competition for prey, as well as direct predation by blue cats and other things. I just wonder, in terms of goal setting for the future, if some of those shifted systems and shifting system problems really create a serious complication here.
Just one additional note as well, that we have university partners beginning studies on blue catfish diet and environmental, dynamics of their diet, including competition and what they're directly predating on the Albemarle Sound area. So that should hopefully provide some very relevant information to this as well.
Thanks very much. Appreciate it.
You got something to share with us?
Yep, so Steve just brought up some of the discard estimates from this FMP update. And in the, I'm just trying to make sure I'm.
Scroll up.
Yeah, it doesn't have dead.
We'll have to get back to you on that one. The table that we're looking at right now doesn't have dead discards.
It provides total discards in this one, but not the dead discards, but just, for the, in the last couple of years, in between 7,000 and 10,000 discards for ASMA.
What do we assume, 6% dead discards, right?
Yeah.
So,
I'm sorry, is that fish or pounds?
That's numbers of fish. But
Okay.
we'll get back with you, and I think this is total, total discards, not the dead discards.
That's Roanoke River plus Albemarle Sound?
No, Roanoke River,
You don't have to answer right now, but what I'd love to see is your best estimates of dead discards in pounds versus the TAL and the Roanoke River plus Albemarle Sound,
yeah, absolutely.
parallel to spawning site biomass. Okay, that'd be fabulous. Thank you.
Sure thing. Anybody else? Got one quick question. Did I understand it that the stocking is going to end in 2 years? There's no plans to go further than that with the stocking?
So this is just this contingency plan that we work together with Wildlife Resources Commission, us, Fish and Wildlife Service. That's a ever kind of changing thing based on results. So this is just the current plan is to stock for at least the next 3 years. All of those fish will be genetically marked, so we can tell the difference. If we do get good wild production, we can tell the difference if it's wild production or hatchery fish. But that's the plan right now. So at the end of those 3 years, we can reevaluate, and we certainly may, it's certainly an option. It's not like this is 3 years and we're definitely going to stop. So
Okay.
we could continue if it looks like it's needed. If we
Okay,
get some
great.
good recruitment, natural reproduction between now and then, we'd rather have the natural reproduction than the stocked fish.
Absolutely. Okay, great. Thank you for the bad news. It is what it is, I know. So, but thank you for your work.
Thank you.
Yes, Director.
Thank you, Mr. Chairman. I just want to offer a little bit of update on our meeting with Wildlife Resources Commission staff we met with them, not last week, week before last, I believe it was, and we sat down with them with some of their upper-level management to discuss the stock assessment results, which they continue to have concerns about, and also the management moving forward. The Wildlife Resources Commission staff still has concerns about the stock assessment and the results. I think most of it particularly about the magnitude of some of the estimates. They also called into question the ability of the juvenile abundance index that we have to actually track year classes. We talked a lot about the very things that Nathaniel has just spent the last half hour talking about, really, and we had those discussions. We discussed management moving forward, and specifically a harvest moratorium, and that would begin in 2024, as Nathaniel discussed. The Wildlife Resources Commission staff said that their commission would not support a harvest moratorium unless we could prove that this minimal harvest season would push the stock into further decline. I reminded the Wildlife Resources Commission staff that in accordance with 03Q0108, that each commission shall implement management actions for recreational harvest within their respective management areas that will be consistent with the North Carolina Estuarine Striped Bass Fishery Management Plan. That specifically is right out of the rule. They indicated that they did not see this as a true joint plan and that they were not bound to this rule. So from my seat, we have watched management action in 2014 and 15 where we basically cut the quota in half for this fishery, and then we reduced it again, as Nathaniel talked about, significantly in 2021. We're currently facing 7 years of recruitment failure, and these trends are just not something that we can live with, in my opinion. The harvest moratorium is very impactful, and we do not take that lightly. We understand what that means to our stakeholders, and we have a lot of work to do to figure out, really to Dr. Rader's point, what is really causing this, and how can we begin to impact that or reverse that. But based on the data that we have, this stock is in trouble. Everything points to that, and I do not think that we can delay this action any further. So I just want to recap really what Nathaniel has laid out. Due to a lack of remaining quota, there will not be a fall season for striped bass, commercial or recreational. And based on the adaptive management available in Amendment 2 that this commission approved in November of 2022, we intend to implement a harvest moratorium that will really begin in 2024. We will come back to you in November to discuss plans for recovery for this stock and address things, talk about how we're going to address things like discards, and we'll probably have some more data for you, Dr. Rader, that you've asked for, and have some more discussion about how does this look moving forward and what are our plans. So, thank you, Mr. Chairman.
Thank you, Director. Yes, Commissioner Rader.
That sounds fabulous, and I hope, I know you won't be, but I hope you won't be shy in estimating mortality scenarios with the Wildlife Commission failing to comply with the harvest moratorium under various likely scenarios there, so that we can see the what-ifs. And for that matter, there's available to the public to see what happens if management failures occur.
Yes, thank you, Commissioner Rader. We will be looking into those things. We will not be shy, I promise you. Thank you.
Can I chime in just one
Yes,
thing real quick?
please.
I think one of the specific notes from the Wildlife Resources Commission was that they weren't sure about our juvenile abundance index being able to effectively monitor the population. But I am one of the folks that directly, along with Charlton, coordinates most of our striped bass monitoring surveys. And we don't just have one juvenile abundance index. We have 3 different surveys that are all highly correlated. We have both trawl and beach sand surveys, multiple different ways of looking for the same signal. And beyond that as well, we also have the adult abundance surveys. A few years later, you would think if, in 2017, if there were actually, millions of fish out there, we would start seeing those in our gillnet surveys around 2020, 2021 in much larger numbers. And really, our surveys have not shown any indication that we're missing any huge signal or any red flags like that. As a biologist, it's one of my greatest fears that we might be missing something, that maybe we're sampling in the incorrect location or something along those lines. But everything has indicated that our surveys seem to be agreeing with each other. And one of the encouraging things for me this year was I've only been here since 2019. And since 2019, we've had consecutive recruitment failures. And so I've never seen a seine survey or a trawl survey that caught large numbers of juvenile striped bass. But this year, immediately after stocking the juvenile striped bass in the Albemarle Sound, we started seeing much larger numbers of juveniles in our trawl and seine surveys. So what that says to me is that our surveys are still sampling the accurate habitat and capturing the juveniles where they are in the sound as well.
Thank you. Okay, thank you for your presentation. Over the last little bit, we have had several rulemaking issues, and I've asked Philip to discuss these. He can articulate it a lot better than I can. So, Philip, will you take over this discussion, please?
Thank you, Mr. Chairman. Yeah, no, muting me might be the better thing by the end of this. So I have 3 issues to bring to your attention, and I hope to bring them in an order that makes it easier and less controversial. But certainly it will increase in controversy, I suppose, be the way it says along the way. But the first thing, as you can see on your agenda, is the CRC floating structures rule. So this commission, at its last meeting, received from Owen an excellent update. Well, thank you. I need 2 microphones.
Talk out both sides of his mouth.
I'm saying, but I'm saying the same thing out of both sides. So the first issue, again, the CRC floating structure rule. At the last meeting, Owen provided you an overview and included a memo from the CRC about floating structures. This is for the harvesting of shellfish, and in that memo, which was written by the counsel to the CRC, who's in the section that I manage, and I had a part in that memo, reviewed it and signed off on it. I know the department did as well. Sean Meyer, your former counsel, now Assistant General Counsel, as well as Christy Goebel. A lot of folks had input in that. Division staff had input in that. And what the ultimate conclusion was that the floating structures are not considered year, and therefore they're considered development under the Coastal Area Management Act, which falls under the jurisdiction of the CRC. As I said, I approved that memo. I agree with it. I know Laura has provided it to you all in your packets. And that rule came before the CRC, the RRC at its most recent meeting this month. Two objections were raised to that. One was about the applicability of the agriculture exemption within CAMA, which is obviously not within our jurisdiction. We don't have anything to do with interpreting or applying CAMA. And the other one was that these floating structures fell within the exclusive jurisdiction of the MFC. As I've told you, it's my position, and I'm recommending to you that that is not the case. The CRC obviously agrees with that position, and even the Rules Review Commission counsel responsible for reviewing these rules agreed with that interpretation, that they're considered development under CAMA and not part of gear that is regulated by the MFC. However, the Rules Review Commission agreed with the objection on authority as to the fact that essentially agreeing with the objection that somehow the MFC has authority over it and not the CRC. So what I would like your permission to do is to work with your chair to draft a letter to the RRC simply stating our agreement with the CRC that it has authority over these floating structures. Again, that's a position that is supported by the department, its counsel, and both myself and counsel for the CRC as well as the RRC counsel. Everybody else seemed to be in agreement with that. Clearly, we will stay away from the question of agriculture. That's, again, not for us to interpret or implement the Coastal Area Management Act, but I would like to get your permission, and I'll recommend to you that I be allowed to work with the chair to submit a letter simply saying that the commission agrees with the interpretation that the floating structures fall within the CRC's jurisdiction and not ours. And I'm happy to answer any questions about that.
Any questions, and would you like a motion for that, or just
Yes.
consent? You would like a motion, all right. Any questions on what this is about? If not, could we have a motion to move forward as outlined? Commissioner Roller?
I'm happy to make that motion. How would you like it worded?
As requested would be fine, so moved would be just fine.
So moved.
Second by Commissioner Sammy. Sammy, okay. Any further discussion on this? Let's do a roll call vote on this.
To the RRC,
RRC.
and not CRC,
Yeah.
to the RRC.
Yeah.
Yeah.
Yeah, that's good. You got a question?
Is this just simply just stating whose jurisdiction it's under?
That's all it is.
Okay,
Yeah,
thank
just
you.
agreeing with the CRC's interpretation.
Yeah.
Yes, sir, thank you.
Yeah. Okay, roll call.
Yes, Chair. Commissioner Bethay?
Yay?
Commissioner Blanton? Thank you. Commissioner Corbett? Yes. Thank you. Commissioner Gardner?
Aye.
Thank you. Commissioner Huggins?
Aye.
Thank you. Commissioner McNeil?
Aye.
Thank you. Commissioner Rader?
Aye.
Thank you. Commissioner Roller?
Aye.
Thank you. And Chairman Bizzle?
Aye.
Thank you.
Motion passes unanimously.
All right, so now, if only it was that simple. If that was the only rulemaking issue I had to bring up to y'all today, that'd make my day just as much as it makes y'all's. Because then you don't have to hear me talk out of either side of my mouth, apparently. So the second issue that has arisen since your last meeting involves the mutilated finfish rule and our friends at the Wildlife Resources Commission particularly. So as you all know, in February of this year, you unanimously passed amendments to the mutilated finfish rule, essentially giving the director proclamation authority to exempt species from that rule's prohibition against mutilation, removing the heads or tails of certain species. The intent was to resolve some confusion in the way the rule was applied. And while it is a very important rule, to say that it is not controversial is an understatement, as you received a grand total of 3 public comments, 1 in favor and 2 expressing some concern, neither of those 2 comments from the Wildlife Resources Commission. So the rule proceeded to the Rules Review Commission, and it seemed to be doing just fine. There wasn't any objection to it there until May of that year, when the Wildlife Resources Commission submitted a letter of objection before it went to before it came before the RRC to approve. And I'm going to say it now, but you're going to hear me repeat this later. But what the WRC said was that this rule was likely to create confusion amongst anglers because it didn't specify things such as whether this applied in joint and coastal waters, which are the only 2 waters that this body regulates. As I pointed out to the RRC Council, we also didn't specify that it didn't apply to the Pacific Ocean or to the inland waters of India or China or any other body. These are the only 2 waters that they apply to. But at the WRC's insistence that we include the phrase joint and coastal waters, and seeing that it did not have any substantive effect on the rule, I agreed to submit that on your behalf as a technical change. The RRC also insisted that we include that it did not apply to inland game fish in coastal waters, which is also true. Again, that's a known limitation to the authority, so it could not have applied to those anyway. But I said on your behalf, okay, fine, it's not a substantive change. We'll make that addition. And then, not being satisfied with that and saying that there now was confusion and the lack of clarity with the rule because it references joint waters, which I'll remind you, they insisted that we include. And so now it's unclear and there's an ambiguity there, and it's going to create all kinds of confusion. So we want you to include a phrase that it says it does not apply to any fin fish used for bait in hook and line fishing. Now, I don't know about you all, but I don't understand the purpose of a rule that exempts all fin fish used for bait and hook and line fishing without limitation, when in fact that's part of the purpose for the mutilated fin fish rule. So that is a substantive change. It is an exception that, in my opinion, swallows the rule entirely. And on your behalf, refused to include that in the rule. It went to the Rules Review Commission, and we had some interesting conversations there, which I'll let you know about later in the next context that we'll be talking about. And to the Rules Review Commission counsel who's reviewing this rule, to his great credit, he did not agree that there was a lack of authority or jurisdiction, but because of the joint waters issue, which was created by the WRC, that there was a lack of clarity and a lack of ambiguity, or there was an existence of an ambiguity in the rule. So the Rules Review Commission agreed. I did get 1 vote in favor, or 1 vote opposed to their agreement with that, and so the rule was objected to. Now, with the APA, the Administrative Procedure Act, and rulemaking, what that means is the rule now comes back to this commission to decide whether to resubmit the rule with modifications that would satisfy the objection or may satisfy the objection, or to withdraw the proposed amendment. Fortunately, the objection was not based on authority, because had it been, the withdrawal of the rule would mean that you lose the rule as it exists currently, right? So no rule at all if it was objected to under authority. It was not objected to under authority, just ambiguity and lack of clarity. So there are 2 things that the commission can do. One is that it can allow me to write a letter to the RRC signaling that this commission intends to submit amended language in the future. I do not have proposed amended language for you right now to consider, simply because I am not entirely certain how we can write the rule any more clearly than it is now. But it is at your leisure to tell me to resubmit the rule as approved initially without the technical corrections to see if that satisfies the objection. I will tell you that that is an act of futility. I don't think that they will. You can also direct me to inform the RRC that you do not intend to amend the rule to attempt to satisfy the objection. And technically, you can leave the rule sitting in limbo for as long as you want. It's not a great idea because it doesn't get you anything. But you can also tell me that that you do not intend to resubmit the rule, and that you want me to withdraw the rule such that the original rule will come back into effect. The problem with that is there was some uncertainty by the division as to whether the director's proclamation authority applies to that rule. I do believe that this commission, in my view, there is an argument to say, yes, it does apply to that. But generally, proclamation authority is used to place some kind of limit on the fish rather than accept a fish from the rule. So there is a little bit of a question there. But you can address that question through an interpretive statement or declaratory ruling that the proclamation authority does in fact apply, such that the director is permitted to issue proclamations exempting species from that rule. I think there are benefits and detriments. There's pros and cons to both, but whichever path you decide, at this meeting, we are required to take some action on it. I know that this will create some discussion about what does it mean, what is the impact. Again, this is not a very controversial rule, but in my view, what the WRC did and what the RRC essentially agreed to was that any rule that this commission passes now somehow is a joint rule, despite the fact that I argued zealously, as you all know, I tend to do that this was not a joint rule. This was not a joint rule, so it didn't require concurrence from the WRC. And so by saying that WRC's concurrent jurisdiction in the joint waters created this ambiguity, the effect is to say everything that this commission does now has to be approved by the WRC. That's certainly not an interpretation I take, and in fact, it's not an interpretation that the WRC adheres to, as we'll talk about later, itself. It only seems to raise this issue, one way. So I have talked with the director, and I don't mean to speak for her, but I think she is comfortable allowing the rule to remain as it was originally, not as amended, as long as there's some clarity about the ability to amend that rule or to apply proclamation authority to that rule. Again, I think that there's some room there, but we can also amend the rule as it exists now. We can leave the rule in place and then add some language to say the proclamation authority applies to this rule. So in other words, the rule is originally written, not as amended, but originally as written, but then add to that a line that says proclamation authority applies to this rule, such that it will allow exemptions.
Commissioner Roller.
Thank you, Chair. So when you say rule is originally written, that was the rule that's already on the books, not this one that we submitted.
Correct.
Just for clarity there. I'll reserve some of my comments.
Commissioner McNeil.
Can we pull the rule up as written right now so we can
Sure.
see
Sure.
exactly what we're talking about?
Do you mind, Laura? Sorry.
I think I've got it right here, but I
Yeah,
want to make
it's,
sure.
it's 15A NCAC 03M 0101.
Okay. Got it.
And what it says is that you can't mutilate a fish by removing the head and tail, except for 3 examples. And the 3 examples are, while Laura's pulling it up, or getting it pulled up, mullet when used for bait, hickory shad when used for bait, provided that, and there's some limitations there, and then tuna possessed in commercial fishing operations. And it cites another rule. So those right now are the three by rule that are automatically exempted. And the intent of the change was simply to say that more fish can be exempted through proclamation. So we can go through that, we can go back to that original language and just add a fourth line that says, the director may exempt any other fish by proclamation, and we could attempt to submit that. I do believe that the Rules Review Commission would likely see that as a substantial change from what was originally submitted to them. But that's not a problem, because all we would have to do is go back out to public comment, a very limited public comment period, rather than having to start all the way over if we were to pull the rule and then try to amend it later.
Laura?
So we're getting the rule pulled up. It's just going to take a second.
Okay, all right. Any other questions? Commissioner Roller?
So just to remind everyone listening and the new commissioners, I mean, the way this is proceeded is obviously frustrating to me, because this is something we had excellent discussion over. And I believe was a very pragmatic solution to remove confusion from law enforcement, as well as many changing regulations that we have, right? And obviously, the issues we face as fishermen in marine fisheries are very different than what is faced in inland fisheries, right? One of the major issues we did discuss is when we look at some of the South Atlantic Fisheries Management Council's decisions, we've decided to exempt Spanish and king mackerel from being disallowed from being possessed if they're mutilated, because they often get bitten in half by sharks or barracuda or whatnot. And if that piece of fish makes the minimum size, we can now retain it. And so while we see changes like this going on in other fisheries, it made more sense for us to pursue this, right? And so I am very interested in finding a way to solve this, not as quickly as possible, right? But whatever allows us to continue going forward to allow for this to be changed by proclamation.
So it's been pulled up, and what you see here is the highlights of what was changed. Now, I'll note for you that you'll see at the last sentence that's highlighted where it says, or a rule of the Wildlife Resources Commission. That is not what they had insisted on. It was more broad than that, but that is what ultimately the RRC Council said that they were willing, that he was willing to accept if we were to put that in there. In fact, he told me that he just didn't see, he wasn't sure of any other way to satisfy that objection with the WRC. I cannot, in good conscience, recommend to you that you allow me to submit that, because it decimates the purpose of the rule, especially in light of the next topic that we're going to talk about.
Yeah. Any other?
But in talking about it, I would say of the three options, the two primary ones that I would suggest is either withdrawing the proposed amendment and issuing an interpretive statement, or allow me to resubmit the rule as originally written to include a number 4. That would say any other finfish or accepted, any other finfish accepted by proclamation.
Yeah, the director has a proclamation authority.
Right.
Yeah.
Nothing, Commissioner Roll has that.
Yes, Commissioner Roller.
The impetus for us pursuing this originally was because when possession limits were put upon spots and croaker, therefore that disallowed them to be used from bait under the law, correct? Right? If we add number 4, would that allow them to be used as bait?
By virtue of a proclamation.
Okay.
Now,
Even though it says, even though law would say would be that is subject to size or harvest restriction or limit, right? That would, a proclamation could exempt them.
Yes.
Yeah, they'd have to be over 4 inches, and you couldn't do more than 50.
So my one concern with that option is even returning the rule to its original form and adding that 4th category of exceptions to do what you're seeking to do is likely still going to draw the same objection from the WRC that we didn't specify joint or coastal, and that the inclusion of joint creates a conflict with their authority. So I can't tell you that with any certainty. I can tell you that it's very likely that we will still get an objection, but we will have, in good faith, attempted to remedy the objection based on clarity and ambiguity. And it would be up to the RRC to determine whether that does in fact satisfy their objection and whether that results in a substantial change requiring going back to public comment for a limited period.
If they object to that, they're objecting to the fact that our director has authority in joint waters.
Surely they are.
Commissioner Corbett?
That is exactly.
I'd like to make a motion.
I'm sorry.
Did you have something else to add?
I was just wondering if if you withdraw it and attempt to alter it that way, does that still comport with the requirement to readopt rules? And again, I'm a scientist.
This is not the rule review and readoption process, right, Catherine? This was just.
I know, I'm just trying to
amendment.
confirm that there's not an entanglement there that we're not thinking about.
Well,
related to
so
that.
even if it is for the rule readoption, rule review and readoption requirement, this commission's already satisfied that requirement by taking action, final action to adopt the rule. It doesn't mean that the rule gets approved, and so it doesn't go away.
I wouldn't know, I'm just
That's
making,
fine.
I'm just
Ask
calling it out.
away, yeah.
Yeah, this is the one area I actually have a little bit more expertise in.
Just,
Okay. Yeah,
I'll pat you on the back too for that.
thank you.
Okay. Commissioner Corbett, you got it?
Yeah, I'd like to try a motion. How about that?
All right.
That we keep the rule as it was originally and give the director proclamation authority. And then send that to them and see.
Add a fourth line in there stating that the director has proclamation authority
Right.
to add other species.
That's right.
I'll second that.
All right. Let's get it up there, make sure we got what we want.
And if the commission, if it's your leisure, I can write the letter to the RRC and say that we intend to modify or amend the rule to satisfy the objection, and then I can bring you language back at your November meeting and say, this is what I would propose. So if that's okay with y'all, we can do that.
I understood that to be the intent of the motion and the seconder myself.
Right.
All right, great. Is that? Yeah. Okay.
Everybody make sure when you talk, have your mics on, please.
I had it on, I think mine's not working. Or I'm just not. No, I didn't. I know it's on now, but I don't know that they can hear it.
Pull it closer.
I just got to get closer. Okay.
Okay. Is that your motion as you made it?
Yes.
Is that the motion as you seconded it?
Yes.
Okay, any other discussion on this motion? Roll call, please.
Yes, Chair. Commissioner Bethay?
Aye.
Thank you. Commissioner Blanton?
Aye.
Thank you. Commissioner Corbett? Thank you. Commissioner Gardner? Thank you. Commissioner Huggins?
Aye.
Thank you. Commissioner McNeil?
Aye.
Thank you. Commissioner Rader?
Aye.
Thank you. Commissioner Roller?
Aye.
Thank you. And Chairman Bizzle?
Aye. Motion passes unanimously. Council? You got Commissioner Gardner. Yeah, and make sure your mic's turned on and.
Can I just say on behalf of the coastal guides that this is a big deal? This may just seem like wording and frustration over possible power grab here, but this is a daily issue for us, and to have the ability to use fish by proclamation was big when this was talked about originally. We have, I would say, almost a dozen different fish that we're using, including chom, commercially ground chom that could be included in this. So clarification is greatly appreciated.
Sure enough. Good enough.
Thank you.
Thank you. Okay, Commissioner Blanton.
Yep, thank you, Mr. Chair. Just wanted to follow up. I know we voted and I know that we're moving forward, but this rule change was intended to protect the fishing public. And that was what the original intent. And we made an honest effort as a commission to identify this issue and to try to rectify so that the fishing public could continue to enjoy the resources and to use a little bit of cut bait. And this not only applies to the recreational industry, but the commercial industry as well, because as we have moved to hook and line gears, i.e. trot lines for the invasive blue catfish that we just heard could be a problem towards a fishery that we are both the WRC and the MFC should have, full spectrum and their eyes on to try to help. So I think this is, unnecessary for us to have to take this back up again. But I think it's absolutely necessary that we continue to push forward and advocate for the fishing public and for us to help them be able to go out and lawfully, use the resource. So thank you, Mr. Chairman.
Thank you, Commissioner Blanton, and I'm glad you brought that point up because what this actually helps to do is allow for more fishing opportunities for people in North Carolina. So, Commissioner Roller.
I just want to say how much I agree with Commissioner Blanton's statement and reiterate what he just said. This was a good faith effort to protect the fishing public, and I thought we did a really good job trying to do that, and I hope that we can remedy this going forward.
Okay, great. All right, we are done with this issue, I believe, but I think we have more to come, do we not?
We do. And thank you, commission members, for your support on that. I've asked if staff can pull up the next rule that we're going to discuss, which is 3Q0106. So, Commissioner Bland, I agree with you 100% also, not that I don't have a vote, so it don't really matter. But that the point was to bring clarity, and probably one of the more frustrating parts is that bringing clarity devolved into what I could charitably characterize as a sandbox fight that we're not even participating in, right? But that brings me to my next point. So I can't get past the idea that the important but not controversial mutilated finfish rule became I guess the line in the sand, and the basis for an argument that there was confusion and lack of clarity because of the joint waters issue. And the reason I can't get past that is, for most of you last year, and actually started before that, the Wildlife Resources Commission took an extraordinary step to decouple its rules for marine and estuarine resources from the rules adopted by this commission, which it had traditionally accepted and relied on, because this commission, while people disagree about the actions that were taken and whether they go far enough or they go too far, and we always hear about issues with data, the commission still acts using data to make its decisions for marine and estuarine resources. That is your charge. Your charge is to adopt fishery management plans for all recreationally and commercially significant species. You have the authority to regulate the manner, the means, the methods, the size, the numbers. You have very broad authority to do that for marine and estuarine resources, and you have a specific statutory charge and process that you are responsible for adhering to. So in 2022, when the WRC decided to do this decoupling, you expressed your concern that the decoupling of these rules would create confusion among anglers by having two different agencies set size, season, bag limits for species, including flounder. Certainly, no one would argue that that is a recreationally and commercially significant species, as is red drum, as is a host of other species that you have managed. And at the time, you did not argue and are not arguing now. I've not heard any of you argue now with the fact that the statute recognizes the fact that the WRC has that authority to manage marine estuary species in inland waters, but that these rules continue to apply in, not only in the coupling of the rules, they apply in inland waters, but also through joint waters as well as coastal waters. Therefore, having what you described in your letter as a seamless regulatory framework for the management of these species. But despite your objection, both during the public comment period, you didn't wait till the end, you said it at the time, as did the division, we have significant concerns about this. The WRC chose to move forward. I appeared on your behalf at the RRC at the time, before joining you on a more permanent basis, to make the same arguments that this is concerning, that this will in fact create confusion. And some of you actually may have read an article this morning that really embodies the very confusion that you predicted and lack of clarity that you predicted, because at a committee of the whole meeting yesterday, the WRC decided to move forward with applying its brand-new inland rules, which it not only adopted on a permanent basis and they got objected to, but when they got objected, they decided to move forward with temporary rules to get those rules in place even sooner. You also expressed your concerns at that point, objected to them at that point. Your concerns went unheeded. But the WRC is now saying that those inland rules for flounder, as one example, apply in joint waters. And the significance of that being that their bag limit that they set for flounder is 4 fish. Your bag limit is 1 fish. And your bag limit is 1 fish because you have determined that, and the director with the division has determined that that fish is overfished, and overfishing is occurring. In fact, this commission had to go to great lengths after much consternation and debate to take significant action to limit the harvest of flounder both recreationally and commercially. The WRC's action now quadruples your bag limit for those species. And what is perhaps most concerning, I would assume to you all, I know it is to the division, and while I don't have a say in policy, I'll say it's also concerning to me, is there is no scientific basis showing that that is an appropriate measure. At the committee, I'm given to understand, there was also talk about the fact that there are 2 different seasons now and 2 different bag limits, and there was an indication that they don't really intend to even apply the prohibition when the season closes, because the MFC has a 1 fish bag limit for flounder, and that season opens after the close of the inland fishing season. So in other words, your concerns and your disagreement with the action has in fact played out exactly as you had estimated. And I'll say earlier this year, I had a conversation with the WRC council, who I like and respect, and I was assured that there really wasn't a problem here, because the changes in bag limits and the decoupling of the rules for inland purposes only applied to inland waters. But they did not intend to apply this to joint waters. The rules would say as they were. And right on cue, yesterday, or day before yesterday, rather, just the opposite is what has happened. And I'm also given to understand that in part, just as you expressed your concern about, that they could not change that 4 fish bag limit because they do not have proclamation authority to do so. A frustrating but very much predictable and predicted outcome. And it would apply to all the other species that they decoupled from your regulations, irrespective of the shape of the stock. One of the complaints that was expressed at the committee meeting was that we have not been working with them cooperatively, and in fact, we didn't share any data with them. And Director Rawls, I'm sorry to put you on the spot, but have you ever refused to provide any data to them?
No, we have not.
And maybe just me, but I'm sure the rest of you have noticed that at every meeting, you are in fact provided data about the shape of whatever stock or whatever species that's coming before you at the time. All of this information is posted online, and if I'm not mistaken, other data is available online. But why is that important? It's important because they've said the quiet part out loud, that the decision was not based on scientific data, was not based on the shape of the stock, but just because they changed the rules and now they say they're applying in-joint waters, which is a practice that has never been used before. It's an unprecedented deviation from how they have handled it before. And it is very frustrating. So what are they using to base this authority on? They've also said that the FMP statute doesn't apply to them, so they're not required to manage species with any particular scientific data without regard to any user conflict or anything else. The rule that's been pulled up, 03Q0106, is the basis for their argument that they have exclusive jurisdiction over hook and line in joint waters. Now, I challenge any of you to find the word exclusive in any of the language in front of you. I'll give you a second to review it. No? Nobody sees it? That's because it's not there. And the reason we know it's not there is because since 1995, we've had a formal Attorney General's advisory opinion that was issued to the Marine Patrol Colonel at the time that says the assertion that either agency has exclusive authority over anything in joint waters is an overreach at best. In fact, just think about the word joint. It's contrary to the word exclusive, right? And you do, in fact, have concurrent jurisdiction in joint waters, which are defined as coastal waters in which a significant amount of freshwater species are found. So in other words, the basis for a joint water is that they are coastal waters with marine and estuarine resources located within them. They also happen to have some freshwater species. But they say this rule, in particular subsection B3, is what gives them the exclusive authority over hook and line to the exclusion of the authority and the regulations of the Marine Fisheries Commission. It is my opinion that that is absolutely not correct. Joint rules were intended to manage primarily jointly managed species. In fact, they came along to address striped bass. And by the way, this rule or this opinion has been in place since 1995. That was the year I started college. Another way to say that is the year I graduated high school. But I don't like to get made fun of. Well, I graduated from Gastonia, Ashbrook, so it's a little easier, I suppose.
14 years.
But this is not a new interpretation. Individuals much smarter than me issued the formal advisory opinion, which went through the approval process that our office has to issue such opinions, which are very rare these days, and was issued to the director. It pertained to shad, but the concept was the same, that this rule does not exclude your authority over marine and estuarine resources in joint waters. It doesn't. But this is the rule that you're being hammered with repeatedly for important and significant species such as red drum and flounder, all the way down to a mutilated finfish rule. Not based on science, not based on data, but based on geographic boundaries, which is what you all expressed exactly as a concern in your letter to the WRC when they decoupled these regulations. understand that yesterday's meeting got a lot of laughs. I wanted to get a few laughs for myself today, but I don't find it very funny. I find it very concerning. Because by quadrupling the bag limit, not only are you undoubtedly going to cause harm to the species, which is the focus of the regulations, the resource. In fact, at the public comment on Wednesday night, you had a group, the CCANC, who handed you an opinion from the Court of Appeals that said you have an important duty to protect the public trust resource. It's their opinion that you're not doing a good enough job. That's the case is going on. We'll let that play out. You're actually not, in fact, a named defendant in that, I want to point out. But if you're not doing a good job and you're using data, what can be said about quadrupling a bag limit without it? So what I'm going to recommend to you all is that you initiate rulemaking, direct the staff to initiate rulemaking to repeal one sentence. One sentence in 15A NCAC 03Q.0106 B3. Now, this is your joint rule. Any modification of this joint rule will in fact require concurrence from the Wildlife Resources Commission. In order to become effective, it will put you into immediate conflict with them. But it is my opinion and my view that a conflict has in fact already been created and already exists. Why is that? Because the WRC has said that it is taking these, it took those actions to decouple the rules and are taking additional action to decouple these rules because it needs more clarity over its jurisdiction. So if it needs more clarity, that means there's a lack of clarity. And if there's a lack of clarity, that means there's a lack of agreement and concurrence. So I think it's absolutely necessary, and all of the rules would in fact, by their own assessment, be in conflict with our rules now. And how do we resolve those conflicts? It's not in front of the Rules Review Commission, although certainly they have a right, just as you do, to object to rules. But where there's a conflict over jurisdiction in joint waters, the governor must resolve that conflict. And it is my view that the decoupling of these regulations and their application of inland rules to joint waters put you in direct conflict already with your jurisdiction. And if this is the rule that they are interpreting in a manner inconsistent with what our interpretation is, because they have their own, it's 10C 0106. If it's that interpretation, let's clarify it by removing that rule. I did not ask for y'all to see, or didn't ask you to pull up the other rules about scope, but I'll tell you the rules on scope, because this section has a scope and purpose rule, which I think are very important. Scope and purpose rules are very, very important. They become less and less frequent under the rules for what can be a rule and what can't be. But the scope and purpose rule says that these rules are not intended to limit any of your respective jurisdictions, their jurisdiction or yours. And of course, we're not working to try to regulate inland game fish in coastal waters, which is a specific legal definition. And there are a list of those species out there. You're not looking to regulate, what was it, Director Rawls, crayfish or freshwater mussels?
Chonoke crayfish.
Yeah, not looking to regulate those. I'm sure plenty of those can be found in coastal waters. And as much time as I spent on the South Fork River catching catfish with my grandfather in Gastonia, I never caught a blue crab at the end of my hook. But they have their own separate regulations for blue crab, and they have their own separate regulations for croaker, bluefish, you name it, it's there. And ladies and gentlemen, this is a problem. And so it's my recommendation that you resolve the problem by deleting that provision of the rule so that the focus can be on the species. As you said in your letter, the focus could be on the species and not the geographic boundaries, especially when they don't even intend to enforce the bag limits at a certain point. So with that, Mr. Chairman, I'm happy to answer any questions.
Questions or comments?
Comment, Mr. Chairman?
Yes.
As a scientist on the panel, I'm offended personally and on behalf of all the scientists, hundreds of scientists, that have participated in the extensive scientific processes that undergird the fishery management plans that are adopted by this commission and translated into rules that manage the coastal and joint waters and the populations that exist there, and want to make very clear that, in fact, all of those, and particularly the Southern Flounder Fishery Management Plan, is heavily steeped in the best available science. And I do not believe that the Wildlife Resource Commission has taken account of that science, nor used it as any basis for their their recent rulemaking, their recent regulatory adoption. Moreover, them taking that action, in my view as a scientist, directly contravenes the requirement under the law that this commission must comply with to manage those species in a way consistent with that science. And in fact, in no way obviates our obligation to continue to meet those benchmarks. So that would directly erode the efficacy of the fishery management plans that we have adopted and the legal and the statutes that we are obligated to defend. And in fact, I believe we would, if they persist in taking these steps, we will have to compensate for them by readopting further, more restrictive rules in other compartments of mortality for each and every species affected by such a rule. Meaning that the failure of those plans and regulations to meet those legal standards would be directly contravened by the actions of that commission. And so I think that I've never seen such bad faith in managing shared resources in the name of the people of North Carolina. So I'm very concerned about it, but any such failure to perform would be directly laid at their action. For the record, that's I've never heard that anywhere in my worldwide experience with fisheries management.
Thank you, Commissioner Rader. Any other comments? Mr. Corbett.
Yeah, I got a question. So to clarify this, and it's on. Pull it closer. All right, to clarify this, so we're looking to take out B or just B3?
Just B3.
Okay, that's what I thought. Okay, well, I'll let somebody else make comments before I make a motion.
And Mr. Chairman, if I may also, two more things. One, I would suggest that the direction be to initiate rulemaking, meaning bringing you back draft language that deletes that provision, but also authorizing staff to make any recommendations it feels necessary to otherwise amend the rule such that the point being is that in joint and coastal waters, again, joint waters being originally coastal waters, that where this commission has set a limit or the director has issued a proclamation that it applies to those marine and estuarine resources, whether they're in coastal or in joint, that being the point of this, right? So that we have no more conflict as to whether the same rules apply in both bodies of water. And I'll add again, the impact of that being that it returns us to the status quo that we were supposed to be maintaining when we readopted the joint rules in the first place as directed by the governor. You all readopt the joint rules, maintain the status quo, If you need to change rules later, you can do that by agreement, but right now, re-adopt the rules as status quo. And I think Commissioner Huggins might get a kick out of this, but this situation reminds me of the U.S. Supreme Court's evolving, really newly stated doctrine called the Major Questions Doctrine. Now, I'll be candid with you, I don't know that I fully agree with that doctrine, but every time there's been a vacancy on the Supreme Court, I have proactively and politely declined to be considered, because I've never wanted to put anybody in a bad situation. Don't have to tell me no, especially because I don't have any plans of leaving the state, either, which is maybe to the chagrin of some folks. But the guideposts to that doctrine include that it applies where there's a different and distinct regulatory scheme already in place, which is exactly what you had, and that the courts are more hesitant to recognize newfound authorities in old statutes, which would include rules, against the backdrop of that agency failing to invoke that authority at any other time previously. Applying inland rules in joint waters to marine and estuarine resources is in fact a newfound authority that they didn't exercise previously. So.
Okay. Commissioner Huggins?
Just briefly, could you just walk me through procedurally, once, if we resubmit the rule with the modification, goes to the, I guess, how it is, just procedurally, where we get to, I guess, a final declaration as to how things should proceed forward?
Okay, so this rule, this action would put you in a different position than the action you just took about the mutilated finfish rule, right? Still, I do crack up a little bit that it's the mutilated finfish rule that creates confusion, but not these other rules. But so this one, you would be initiating new rulemaking. So you would have to start with the staff bringing you back language, a regulatory impact analysis, necessary fiscal note, although I don't see one being required, although that's the purview of the Office of State Budget Management. So you would be submitting as a new rulemaking action a rule that deleted that repealed that provision. Now again, if you were to take the actions I'm recommending, and you were to go all the way through the rulemaking process, and you were to finally adopt an amended rule that no longer has that provision or deletes that provision, it would not go into effect unless and until either one of two things happens. Either wildlife agrees, I wouldn't hold your breath, or the governor allows it, or finds some other remedy, and only then would it proceed to the Rules Review Commission, just exactly as your joint rules did previously when there was a conflict between the joint rules you readopted without substantive changes and the joint rules that wildlife attempted to adopt with substantive changes, right? So at that point, you both had taken final action, but you had to go back and kind of redo that with the same rules, the same rule language. So that's where you'd be here, and that's going to be different. So it doesn't get to the Rules Review Commission at its next meeting, unlike the letter I'm going to be sending about the mutilated finfish rule related to the action you took earlier.
Does that clear you? Okay, great. Any other comments? If not, Commissioner Corbett, I think you have a motion to be made.
I think I do, but I'm not a lawyer, so
That's the best thing
we'll
about
let the lawyer straighten out any mistakes I make.
You must be talking about Commissioner Huggins.
So I would like to direct staff to proceed with new rulemaking action to take out B3 from the existing rule. Is that close?
Yeah,
And
what they have up on the screen.
I think the best defense is a good offense. I will second that.
Good enough. Okay, second by Commissioner Huggins. Okay, make sure that's the motion as you made it.
That's it.
Okay. And Commissioner Huggins, motion as you seconded, correct? All right. Any further discussion? Not, let's have a roll call vote on this, please.
Commissioner Bethay?
Aye.
Thank you. Commissioner Blanton?
Aye.
Thank you. Commissioner Corbett? Thank you. Commissioner Gardner?
Aye.
Thank you. Commissioner Huggins?
Aye.
Thank you. Commissioner McNeil?
Aye.
Thank you. Commissioner Rader?
Aye.
Thank you. Commissioner Roller?
Aye.
Thank you. And Chairman Bizzle?
Aye.
Thank you.
Motion passes unanimously.
And so thank you, Commissioners.
Yes.
That mercifully ends my section of it. I'll try to be quiet the rest of the time, but who wants to give me odds on that?
Not me. I have already won $1 from you.
Yeah, you did. All right, thank you all very much.
Yeah, thank you, everybody. This is kind of tedious, but it's where we are. Okay, rulemaking update. Catherine, please come on up.
Thank you, Mr. Chairman. You know I like to be up here and ready, but I'm doing 2 jobs today, so sorry for the pause. Okay, I'm Catherine Bloom. I'm the division's rulemaking coordinator. Most of you know me, but there's a few new folks. And I will start with some information that some of the commissioners have heard over the last couple meetings. But for our new commissioners, I did want to provide 2 quick reminders about statutory requirements that affect your rulemaking activities. So first, North Carolina General Statute 150B-21.3A, the periodic review and expiration of existing rules, requires state agencies that implement rules to review existing rules every 10 years in accordance with a prescribed process, and that process begins with a report phase, and it's followed by rule readoption as if the rules were brand-new rules. So you have only one more package of rules to readopt in order to satisfy those requirements from the first iteration of the periodic review, and I'll detail that shortly. For the second iteration of the periodic review requirements, effective June 1st of this year, the Rules Review Commission approved the report deadlines for all state agencies. And for your rules, the final reports will be due in early 2027. And I'll be providing further information to you as that time approaches. I know 2027 may sound far away, but in rule timing, it's on the near horizon, so it's really not that far away. The second statutory requirement is regarding Session Law 2019-198 and General Statute 14-4.1. And these laws require any rule that creates a new criminal offense or otherwise subjects a person to criminal penalties is automatically subject to legislative review. And you have about 375 rules in total, and about 1/3 of those are impacted by these laws. And essentially, the requirement adds time to the rulemaking process. So both of those are sort of overarching things going on affecting your rulemaking activities. So the material I have for you today is in the rulemaking update section. There's several documents for you, but the first one is a memo. And if you want to follow along, that's probably the easiest one to just follow. And I'll pause for just a second if you want to refer to that part of your briefing materials. There's a rulemaking section, and the memo is first up. There are no actions scheduled for you today under my report, which is rare. And so the update's fairly short. All right, first up is your 2022-2023 rulemaking cycle. At your August meeting last year, you approved notice of text to begin the process. So Commissioner Huggins, that's what you were just asking about as far as the procedurally how to get going. So you all began that rule package last year. There were only 2 rules in it. One of them was the mutilated finfish rule, and the other was a rule called marinas, docking facilities, and other mooring areas. Long title, but one rule. So there's a table in your materials that shows the steps in the process from that cycle. And you did give final approval of both of these rules at your February meeting this year. And the marinas rule was approved at the May Rules Review Commission meeting and then became effective June 1st. And on June 1st, we issued a news release and a rulebook supplement, and a copy of both of those are in your materials. And then at the June meeting, that is where the RRC objected to the mutilated finfish rule, and council has just covered that rule with you. But that's how it fits into the annual cycle of where things were. So next up is an update on the 2023-2024 rulemaking cycle. And at your May meeting this year, you approved notice of text to begin the process for a much larger package. Last year was 2, and this year was 103. But it did have 4 subjects in it. The first one is readoption of shellfish, plant, and inspection rules. That is the group of rules that is the last of the readoptions from the first iteration of the periodic review. So it's 85 rules, and 79 of those are those readoptions, all about shellfish, plant, and inspection rules. So the second subject is data collection and harassment prevention for the conservation of marine and estuarine resources. The third subject is oyster sanctuary rule changes. And finally, the last subject, conforming rule changes for the Shellfish Relay Program and shellfish leases and franchises. So again, the same kind of table showing the steps or in the procedure of initiating rulemaking and all the things that come after that. That table is in your materials. These rules were published in the North Carolina Register as proposed rules on August 1st, and we did issue a news release on that same date. And both of those documents are also in your materials. So I think it was Commissioner Gardner reached out and said, my goodness, there's a lot of rule stuff in my briefing book this time. There is, but at this meeting, again, it's just information for you to keep you updated on what's happening, no actions today. So we do have a 60-day public comment period ongoing now. It started August 1st, and comments will be accepted through 5 p.m. on October 2nd. We did have a single public hearing that we held via WebEx on August 16th, and also had a listening station at the Division Central District Office in Morehead City. And Commissioner Huggins, thank you again for being willing to serve as our hearing officer. You'll be receiving an update on any public comments that we receive in the entire 60-day period, both written comments and any comments from the public hearing at your November meeting. And that is where you'll be scheduled to give final approval of those 103 rules. The proposed rules would have an earliest effective date of April 1st of next year, except for the rules that are automatically subject to legislative review. The timing should work out that those rules would be available during next year's short session, but it's always a little bit uncertain exactly when the legislature will begin its session. So I don't want to overpromise on that, but that's what we're certainly aiming for. And the last item I have is a preview of your 24-25 cycle. So staff members have been busy this summer working on several different rulemaking items. Subjects under development include management options for false albacore, simplifying pot marking requirements. Both of those came at the request of the commission. And then staff has identified some proposed changes needed to some of the permit rules. So we are working on the materials for those, and the rulemaking process is scheduled to begin at your August meeting. It is our goal to bring those issue papers to you at your February meeting, ask the commission to select your preferred option and the associated rulemaking language. That will allow the fiscal analysis to be done for each of those 3 topics so that we have everything ready to go at your August meeting next year. So we'll keep you updated at each of the meetings on the progress. I think that's everything I had for the rulemaking update, unless there are any questions, Mr. Chairman.
Any questions of Catherine? Great. Catherine, thank you very much. You do such an important job for us. Okay, at this point, we usually allow commissioners to bring up any issues that they want to see addressed in the future. Do we have anything that we haven't addressed today or yesterday that we would like to see addressed in the future? Commissioner Corbett.
Okay, let me see if I can talk into this. Can you hear me, Laura? Thank you. I would like to get the division to bring back to us, and we're having a lot of people that are trying to say there's a lot of commercial landings that aren't getting documented. So what I'd like to know is, I would like to know how many of our 50-some hundred licenses have no-trip tickets, how many have between 1 and 10, and how many have 10 or more, and then if there's any way possible, how many head boats have a commercial license, or not head boats, charter boats have a commercial license now.
Okay.
If that data is possible. I know we did it one time when I was chairman before, so. It just give us an idea of what's going on and how many licenses there really are that, are not being used.
I think they get that data for us. Okay, anybody else for anything? Commissioner Rader?
I brought this up before, and I know we're all aware of it, but I'm quite interested in what the evolving knowledge about the changing East Coast and how that's likely to change the decision-making that this body needs to make at the scale that we work at, and particularly the movement of stock distribution and abundance patterns up the East Coast, the suitability of habitat provisioning there, and in some ways, as dominant species change, as blue cats in the Albemarle Sound, the interactions among them, and thus the potential for these bodies of water, changing potential for these bodies of water to support what we have had in the past versus the future. And I'm just wondering if perhaps staff could, you did report to us at one point on some of those climate assessments that are being done by other fisheries management bodies. I just wondered if we could get an update on where those things stand and perhaps some options for application to our waters. And the one that I'm interested in particularly is the Albemarle Sound, and particularly given the failure of river herring recovery, the challenges we've had with striped bass and actually blue crab too. And I wonder whether some of the multi-species modeling that's been done in Chesapeake Bay might be actionable for us or applicable for us in Albemarle Sound, looking at multi-species management there, taking into account blue catfish and other invasives and changing habitat and water quality and quantity and physical characteristics there. And so at some point, if you could just brief us on whether there's something we might be able to do or try to find resources for to be able to think about future goal setting for our fisheries.
Okay, that may be a huge undertaking. I know your concern of it, because I have that concern too.
It
but-
totally is, but a briefing on where things stand
Right.
for me
yeah.
would be really helpful.
Okay, we can see what we can get together. Okay. All right, anything else from anybody? Commissioner Roller?
I just bring this up because I believe of its importance, and just to keep the conversation going, I'm looking forward to hopefully getting the division's findings or whatever on my previous request to look at how we could possibly enforce South Atlantic for hire permits.
Okay, anybody else? If not, Laura, what have you gleaned from these meetings that you must undertake?
All right, let's see how I do. Thank you, Chairman. So based on today's action, Commission Council will be moving forward with the actions that you took for both the CRC floating structures rule and the mutilated finfish rule. In addition, staff will begin to work on drafting the issue paper to develop the rule language for 03Q 106, which is the applicability of rules joint waters. Moving into upcoming events, I'll draw your attention to the printed copy of your work plan, which is in your folder. And this is also available online in your briefing materials. And just as a reminder, this work plan lays out basically the scheduled commission activities over the next few years. So for your next business meeting, which is scheduled for November 15th through the 17th, you'll be meeting at Emerald Isle at the Islander Hotel. So we're going to be in the same location as we were last year. Division staff anticipate bringing you the updated blue crab stock assessment. And at that meeting, you will also be reviewing the draft amendment 2 to the striped mullet FMP and voting on sending it out for public and AC review. You'll also be reviewing the goal and objectives of the oyster and hard clam FMP and voting on approval of those. And with that, that concludes my remarks.
Thank you, Laura. Appreciate that very much. Like to welcome our new commissioners and a recycled one, and those that were reappointed. I think we did some good things these couple of days, and look forward to more good work out of everybody. And don't forget to leave your name tag on your table, please. And until November, well, and leave your flounder. I appreciate Glenn bringing those, but we got to leave them right there. Yeah, can't take it home. But until November, everybody be safe, and meeting is adjourned.